5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth. Now I'm talking and you just cutting me off. Do you understand how this process works?
Oh, yes. Come on. This is not slavery. I'm not the one. I am not the one. I don't have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to. I don't have to answer you, and I don't answer to you. And I'm not going to start now.
The courtroom went from calm to complete chaos in seconds. One man walked in confident, loud, and convinced he knew the law better than the judge. What followed wasn't justice in his favor, it was a real-life lesson about what happens when ego walks into a courtroom without knowledge.
25S00791. FY, people say the Michigan versus Timothy Dan Smith.
That on behalf of people.
Illinois, P8746, Stephen in for the attorney of record, Bob Donald, and appearing on behalf of Mr. Dansby, who stands to my right. Mr. Dansby, can you please state your name for the record?
My name is Timothy Dansby, and I'm about to represent myself and take counsel as an assistant. You know, I don't know who this being here. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer? You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork I haven't received my discovery.
Well, that's what we got lawyers for, sir.
To the count machine to get to the lawyer very well to the county. So it's apparently hard. So I'm gonna need some type of system.
Okay, well that's what we got for you. Okay.
I'm gonna represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first is I wanna go ahead on with the preliminary.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge.
I believe it's 5 years.
Yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a mouth because I got a brain to go with it.
Well, you can have a, but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. If nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying.
The hearing began with tension in the air. From the moment the defendant entered the courtroom, it was clear he wasn't there to cooperate. Instead of listening, he talked over the judge, challenged her authority, and spoke as if the courtroom was a debate stage instead of a legal proceeding. He repeatedly claimed that he didn't recognize the court's power over him. He spoke confidently, but his confidence was empty, because confidence without knowledge is dangerous in a courtroom. The judge tried to explain the process, but he interrupted again and again, turning a serious felony case into a personal argument. At one point, he couldn't even decide whether he wanted a lawyer or wanted to represent himself. One moment he demanded legal representation, the next moment he rejected it, not understanding that the choice he was making could change his entire future. This confusion didn't help his case, it weakened it. Instead of responding to the actual charges, he went off on unrelated speeches about history and the legal system. The court wasn't there to listen to opinions or personal philosophies. The court was there to address a crime. The judge reminded him that rejecting the legal system does not make charges disappear. As the hearing continued, his behavior became more aggressive. The judge showed patience, gave him multiple chances to calm down, and warned him clearly that his actions could lead to additional consequences. Still, he chose to argue instead of cooperate. Eventually, the courtroom reached a breaking point. The judge ordered his removal. Not because she wanted to silence him, but because respect for the court is not optional. When you refuse to follow basic courtroom rules, you don't prove strength. You prove that you're unprepared for the reality you're facing. This moment became a powerful example of why felony cases are not a game. The legal system doesn't reward loud voices. It rewards preparation, respect, and understanding of the law. Walking into court without those things is like stepping into a storm without shelter.
You have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause. state. So preliminary examination is the probable cause hearing, where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one to commit it. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. So you understand all that. Now, you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Danby today, and have not received any audiovisual discovery from my understanding.
I like to John, if you don't mind, part of the motion, you know what I'm saying, for the fact that I haven't been denied, you know what I'm saying, and it's happening now, you know what I'm saying, and the prosecutor was conduct, we see a lot of government change, even though.
Sure. Okay, that's a lot of talking. There's no, where's the prosecutor? Where's the prosecutorial misconduct?
Well, I should have had my discovery, dog.
Sir.
Yeah.
Do you understand how this process works?
So,
Well, no, you shouldn't have had your discovery because this is the first hearing.
in the first year, I don't prepare anything if I don't have any factor.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just say, oh, yes, come on, this is not slavery. This is not it. This is not the one, you know. I am not the one. I don't care nothing about the United States. First of all,
apparently not.
court,
You must not care too much about anything,
I
sir.
have a life record for it.
Okay.
I don't even have a life record. What's your likeness number?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days? No, you don't care. That's why you're here charged with something.
What is your life number?
I don't have to answer you, and I don't answer to you, and I'm not going to start now. You need to settle down.
Lord, the attorney must be like this by the state.
You need to settle down. Okay, take him out of here, please. That's okay.
I apologize.
He's just having his moments. We're gonna adjourn this, and I'm gonna waive the 21-day, 7-day rule for this discovery. Welcome to Friday. All right. So, we'll give you, what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And he's going to want to see it. So you're probably going to need to have him take a laptop over there to the jail and take his license to practice law to him. Okay. All right. So the next probable cause conference on this charge is going to be.
All right, I just, to make a record as regards to that discovery, I do have paper discovery, which Sister Counsel has noted that has been tendered already. I do not have, does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on
Court's available August 25th at 9:30.
August 25th at 9:30, and hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Gonick will be in trial in the William County Circuit Court. I make that paperwork for myself, but if you're wanting Mr. Gonick to be here,
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance that I would feel more comfortable if Mr. Gonick just handled his own.
Well, you know what? You got to cut your teeth somehow. We've all had this.
Just don't.
Ask Miss Gracie. Okay. Ask Mr. Poodle. We've all dealt with difficult clients.
We got this Gracie right. And he's an expert in this.
I've had my share over the years when I was licensed to practice law. So, by his standards, I'm not licensed. Okay. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.
This case is a reminder for everyone watching. Court is not a place for ego. It's not a place for internet arguments, conspiracy theories, or personal beliefs about the legal system. It's a place where your future can change in minutes. Representing yourself in a serious criminal case without legal knowledge is one of the most dangerous choices a person can make. You're not proving independence, you're risking your freedom. The courtroom doesn't care how confident you sound. It cares about facts, law, and procedure. If you're ever facing serious charges, the smartest move is to respect the court, listen carefully, and get proper legal representation. Silence and strategy will protect you far more than arguments and attitude ever will. Real courtrooms don't reward pride. They reward preparation. Follow for more real courtroom moments where one decision changes everything.